Good morning. Today is October 17th, 2024. It's approximately 9:30 a.m. This is the matter of an appeal by Sanctuary Inn Z0406-23. My name is Carl Cox. I'm a private attorney appointed by Clackamas County Board of Commissioners as the Land Use Hearings Officer with authority to conduct this hearing and make a decision in this matter. I'll state for the record that I have not received any ex parte contact, meaning no one contacted me outside of these proceedings to try to persuade me concerning a fact or issue present in this matter. I have also considered issues of bias and conflict of interest and have determined that I do not have any bias or conflict of interest. The county is making a record of this hearing. That record is available through the county. This is a quasi-judicial land use hearing, which means two important things for those participating in this hearing. First, all of the criteria that can be used in reaching a decision have been identified in the staff report. Testimony, arguments, and evidence must be directed towards the criteria identified in the staff report or other relevant criteria found in the comprehensive plan or other land use regulation that the person believes applies to the decision. Accordingly, please direct your testimony to a relevant approval criterion. Second, failure to raise an issue accompanied by statements or evidence sufficient to afford the decision maker and the parties an opportunity to respond to the issue may preclude appeal to the Oregon Land Use Board of Appeals on that issue. Failure of the applicant to raise constitutional or other issues relating to proposed conditions of approval with sufficient specificity to allow the local government or its designee to respond to the issue precludes an action for damages in circuit court. Once final, this decision may be appealed to the Oregon Land Use Board of Appeals. At this time, I'll ask the county to provide an explanation concerning participation in this hearing via the Zoom platform.
This public hearing will be conducted virtually using the Zoom platform. Panelists for today's hearing, which include the hearings officer, county staff, the applicant, and their representatives, have both audio and video capability. Audience members who have joined the meeting will have their mics muted unless they wish to testify, in which case they will be called upon to do so by the county staff moderator. Audience members' videos will not be turned on at any time. Today's hearing is being recorded as required by law. The county will make every effort to post the recording on the county website later today. There is a designated time during the hearing when it will be open for testimony. The hearings officer will make it clear when this is. If you want to provide testimony, you will utilize the raise hand feature. Attendees on PC and iPad, likely have a raise hand button on the Zoom bar that's either at the top or bottom of the screen, depending on your device. When the moderator switches you over to provide testimony, your screen will look different for a little while. Primarily, you will see all the participants' cameras, not just the one who is speaking. Staff will call upon you when it is time for you to provide testimony. Be sure to provide your name and mailing address when you begin. Once you have provided your testimony, your mic will be muted and your screen will be returned to normal. If the record is left open at the end of this hearing and you wish to submit additional written testimony, email the written testimony to myself, Joy Fields. Email is jfields@clackamas.us, or mail the testimony to Clackamas County Planning and Zoning Division, 150 Beaver Creek Road, Oregon City, Oregon, 97045. The staff contact and email address is also available on the webpage where you found the Zoom link for today's testimony or today's hearing. Testimony must be received by 4 p.m. on the day the record closes. People who testify and provide their mailing address will receive a copy of the hearings officer written decision. If you do not wish to testify but would like to receive the decision, you must provide your email and standard mailing address by emailing the staff contact for the application or by entering it in the Zoom chat function during the hearing.
Okay. So the order of proceedings will be that I will ask the county to begin by presenting evidence that the county wants me to consider in reaching a decision in this matter, followed by the same opportunity for the applicant, appellant in this case. Then there will be an opportunity for members of the public to present evidence and testimony on behalf of the public. I may provide a rebuttal period for the parties as well. Before I close the record in this matter, I will provide an opportunity for participants to request that I keep the record open. And in any case, as Ms. Field stated, the record will stay open until 4 p.m. on the day the record closes. So we'll discuss that further after receiving evidence and testimony at this hearing. Please begin, Ms. Fields. And will you be submitting your PowerPoint? You're muted too. Will you be presenting your submitting it as evidence?
I will.
So let's call that Exhibit 10.
I will save it as a PDF and upload it to a Acela.
Thank you.
Yeah. So as hearings officer Carl Cox mentioned, this is an appeal hearing for Z0406-23. That was a land use application for non-conforming use verification and alteration. The applicant requested a verification that the use was non-conforming and asked approval to make alterations to an existing building to convert it from one dwelling unit to 3 separate dwelling units to better serve the clients with families, and providing 3 different cooking areas, sitting areas, and apartments for the people being served by Sanctuary Inn. Sanctuary Inn bought the subject property in 2017. And the property consists of 2 separate tax lots, both in map number 37E05BD, tax lots 900 and 1000. On those tax lots, there is the Residence Inn, which is the existing building that the applicant requested to modify. There is a lodge, and then there is a cottage, in addition to other structures. The Residence Inn is the site of the proposed alteration. The properties are zoned recreational residential, and that is a zoning district that became effective for the property in 1967. When that zoning district originally applied to the property, it allowed for guest ranches, lodges, motels, and similar resort operations and use as a primary use. No conditional use was required for those uses of the property. The applicant indicates that the resort operation began in 1968 after the initial zoning and in line with the allowed primary uses of the land. Previous owners, Youth Guidance Properties, received approval and verification of a non-conforming use in 2006. And so as we are looking at this non-conforming use application, there are a couple of dates to think about. One is 2006, because that's the last time that the county verified that the non-conforming use was indeed a non-conforming use. And then the other is the 10 years prior to the submittal of the land use application in 2023. On the slide in front of you are the floor plans for the existing building. As you can see, they are being modified slightly to go from 1 dwelling unit to 3 in the same structure. The footprints are not being proposed to be altered, but the inside would be more than the current zoning would allow without a non-conforming use alteration. under the current recreational residential zoning district requirements, you can have one primary kitchen and one accessory kitchen in a structure. And they are requesting 3 kitchens. Therefore, they are requesting a non-conforming use verification and alteration. The first part of the non-conforming use verification and alteration application was a look at the last 24 months, as well as a look at the use of the property in the 10 years preceding the submittal of the application. As I mentioned, the application was submitted in 2023, and the last verification of the non-conforming use occurred in 2006. And therefore, evidence was needed for the staff to be able to determine if there was a discontinuation of use for a 24-hour period between the last verification and now, or at least between 2014 and the submittal of the application in 2023.
You meant a 24-month period, correct?
Well, when it is a 24-month discontinuation period that has to be verified, but the existence, continuity, nature, and extent of the non-conforming use has to be verified for the 10-year period immediately preceding the date of the application. And so there's at any time during that 10 years, if the use was discontinued for 24 consecutive months, then it was discontinued.
Yes, I understand.
And so that's where the dates are a little bit wonky.
Okay, and maybe I misheard you. I thought I heard you say 24-hour period. Never
And if I
mind.
misspoke, I apologize.
Well, I just like to make sure that I understand what people are saying to me. But
Yeah.
thank you for clarifying.
You're welcome. So there was a lack of evidence in the application that Youth Guidance Association continued the use of the subject property for the treatment and retreat use between 2006 and 2017. And so without evidence that the retreat use and treatment center use of the property continued between 2014 and 2023, staff was unable to verify that the non-conforming use had continued in existence, continuity, nature, and extent for the 10-year period immediately preceding the date of the application.
Thank you.
The applicant is not requesting the restoration or replacement of a non-conforming use after damage or destruction. But the applicant is requesting an alteration of a non-conforming use. When staff look at an alteration of a non-conforming use, we have to determine whether the proposed use will have a greater adverse impact to the neighborhood than the existing structure or physical improvements or the use. Staff did not find that converting the existing structure to 3 dwellings would have a greater adverse impact to the neighborhood. The properties are large, and the number of people being served, it would likely not change, but it would allow for greater service to families. And so staff did not find any greater adverse impact. However, we were unable to verify the use. And so the criteria for alteration also requires that it be verified, and thus this criteria was not met. Therefore, staff denied the application as seen in Exhibit 1 because the 120604, 120605, and 120607 were not met. For those participants wishing to receive a copy of the decision by the hearings officer. My email is there as well as on the website.
Thank you. I'd like to provide an opportunity for the applicant appellant in this matter to present evidence, including testimony or other written evidence in this matter in support of the application. And I'm assuming there's no dispute concerning the findings by staff of areas that they found that the application was conforming. Just this specific piece here, correct?
Yeah. That's correct. This is Gary
and there's
Lincoln.
and the proposed conditions of approval, there's no dispute about that either, correct?
No, the only issue that it seems to be of concern in this particular case, and what we need to present evidence on, is the non-conforming use.
And
the
can I
fact that
have
it
you
was
state?
continued.
Can I have the speaker state their name?
Sure. This is Gary Lincoln.
Okay, thank you.
I'm the attorney for Sanctuary Inn. Bar number 923766. Address P.O. Box 636, Welches, Oregon 97067. What I'd like to do, just focus on this particular issue. I think the first one, I just basically have two people that had worked for youth guidance. And working at youth guidance, they worked in this particular location, and just to make it clear for the hearings officer, Sun Village, SON, Sun Village, was the name that was used for this particular facility that was operated by youth guidance. So if you hear referrals to, I worked at Sun Village, they're talking about this location. What I think would be best is to call, if I could call Dan Rogers first, since he's on the cell phone, and let him present some evidence to you. That would be the best initial first step.
Perfect, thank you.
Dan Rogers, Dan, are you there? Did you have him switched over to so he could? Dan?
Just a minute so he can unmute himself, perhaps.
There we go. Is that working?
Yes,
No?
sir.
Okay, Mr. Rogers, I believe you need to state your name. Well, do you need to swear him in first?
No, he can state his name and his address.
Mr. Rogers, would you please state your name, full name and address?
Yes. My name is Daniel Reed Rogers. My address is 17855 Wolf Drive, Sandy, Oregon, 97055.
Mr. Rogers, you're familiar with the property that's at issue in this case?
Yes.
And in what way are you familiar with it?
I have worked with youth guidance associations since 1980, and I eventually became the program director at Sun Village, which is the property we're talking about. And so I continued to work for youth guidance until June 30th of 2016.
And in what capacity did you work for youth guidance?
As I mentioned, I was the program director for Sun Village.
And what did that entail?
Oh, well, it entailed a lot of different responsibilities, but I think of most importance for this hearing is that I was in charge of the intake of the residents that came into the program and exited the program. I was the one that was screening the youth for the program and their appropriateness for the type of structure that we had. I mean, there were staff supervision, and I had a caseload, so a variety of different responsibilities, but I think the intake function of my job was the most relevant.
And how long did you work at the Sun Village location?
I started there in the summer of 1982.
And was your work continuous through June of 2016?
Yes,
And in that entire time, were there boys staying at the facility?
yes.
And on an average,
We contracted, I'm sorry, we contracted for youth. Typically we'd have 15 youth in the program, but there were times where we also contracted for up to 17 youth.
and what was the goals? Where were the youth coming from? What program were you contracting with?
Well, originally it was Children's Services Division in the state of Oregon. And then, of course, that changed over to DHS and also Oregon Youth Authority, which that was the contract that we held.
So there were boys occupying somewhere between, on an average of 15 boys occupying the property from what dates to what dates from your experience?
Are you asking the average length of time that the youth were?
Well, what you
I'm
said
sorry,
is
what?
there's on the average, there's about 15 boys in the program at any given time, correct?
Correct.
Okay, and that was continuous from what year to what year?
Oh, okay. I would say for as long as I worked there, so as long as I was at Sun Village from, I believe it was August of 1982 until June of 2016, we had youth in the program. But once we realized we were closing the program, then it was a matter of helping each of the youth that were in the program to move on to an appropriate exit, you know, for themselves. So we dwindled. The number went from 15 probably back in fall of 2015. 2015 to throughout the year, we were just managing the aftercare plans for each of those youth.
And when did the last youth leave the program?
He left June 28th of 2016.
Right. And how do you know, where do you get the dates so accurate for that?
Well, I have a spiral notebook that I kept for my own purposes because, again, I was in charge of the intake and exit of the youth. So I kept this for myself, and I still have it. In addition to that, I have a calendar, a personal calendar for work that I also recorded some aspects of, you know, graduations of the youth or terminations. So anyway, between those two documents, that's what I'm referring to.
So the standard
Mr.
records.
Linkus, just a moment, Mr. Linkus.
Yes.
So you're going to submit these records as evidence?
We're going, here's the issue. We're going to get to it right now. Is those records are confidential because they include the youth. So redacting, if we redact everything out of there, that would be how we, you know, all those names and everything we have and issues that are in there. So we don't have the ability to do that. So let me just get to the next couple of questions with Mr. Rogers. Mr. Rogers, are the records still available for Sun Village for that period of time?
You know, that's a good question. I didn't, my job did not get involved as an agency as we contracted with the Oregon Youth Authority. That was the executive director and his bookkeeper that managed all the paperwork. I did submit all this information and verify it every month with the bookkeeper to make sure that my records jived with Oregon Youth Authority. But that capacity I don't have. I know this, that we had to hold on to all of our records for 8 years before we could get rid of them. And so that has expired. And I know that the storage facility that we were renting to keep all these records, we no longer have. And I believe those records have been shredded. I just know the records I have right in front of me.
Right.
Oh, and I did talk to the book. I'm sorry. I also talked to the bookkeeper within the last couple of days, and she was going to search any records that she might have that have not been shredded. We're basically thinking a contract that shows the use name as they were exiting the program would be of help.
So I really have no further questions of Mr. Rogers this time. If you have any questions for him, Mr. Cox?
I understand why you can't submit necessarily this a complete copy of these records, and the same issue would apply to exit records for any of these youth. So I don't think you can submit those written records without significantly redacting them and showing only that there was somebody there during the periods. But if you want to submit something like that, I would consider it.
Okay, so we will do that. The other thing that I've done is to try to confirm this. I have made a public records request to the Youth Authority and asked them if they still have copies of at least the contracts during that time, that if it was possible for them to provide those. So we would like to leave the record open. They told me they don't know if they have them or not. I've made that request several weeks ago. I haven't heard anything, but we would like to leave the record open. Also, there's a possibility that there is a box of records that may still be around showing some of the contracts. And what I basically was looking for, and I had asked them, is just the general overall contract information. So we would like to leave the record open for a couple of weeks.
Oregon Youth Authority should be able to provide a record of the last payments.
To that. Beg your pardon?
They should be able to provide a record of when they quit paying.
Yes, yeah, that's what we're looking for, is anything that shows that closing time. So
Okay.
and that's
how much time are you requesting?
2 weeks. I'd like to see if we could get it next couple of weeks.
And are you also requesting that the timeline for this be extended?
Yes, we're willing to extend the timeline.
Okay, then
for a decision.
We'll talk about this some more about how long, but I'm going to just state right now that I'll keep it open for an additional 2 weeks and extend the record an additional 2 weeks. But let's proceed. Do you have another witness?
Yes, I do. And if we can excuse Mr. Rogers.
Thank you for your participation, sir.
Oh, you're very.
He's gone. Yes, I'd like to have Mr. Larry Geisinger. Larry, you want to state your full name and your address?
Full name, Larry, middle name, Van, V-A-N, Geisinger, G-U-I-S-I-N-G-E-R, address 59235 East Highway 26, Sandy, 97055.
Thank you, sir.
And Mr. Geisinger, are you familiar with the property that's the subject of this appeal?
Yes, I am.
And how are you familiar with it?
Well, my position, my last position until we sold was properties and facilities management, as well as staff training and food acquisition. And then after we sold the property and the boys were no longer there, then there was security checks and kept an eye on the facility for wear and tear.
And when did you first become employed with youth guidance?
Be about 1975.
And in
May,
that first role, where were you located at that time?
was located mostly at Sun Village.
And that's the subject property, correct?
Right.
And did you ever actually live on the side of the facility at that time?
That would be like the second thing that we did, and we used a house parent role model at that time in the residential treatment world. And so my wife and I were house parents, and we oversaw 5 to 6 kids specifically, and helped oversee the whole 15 boys when they were there.
And how long did you work there? So what date was the last date that boys were there?
The last date the boys were there was June 28th. And I worked there 40 years.
And June 28th of what year?
Excuse me, 2016.
2016. And
I worked there 40 years.
And so between the time that the boys left, the last boys were out of there in June of 2016, and the time when Sanctuary Inn took over was approximately how much time?
We were done with the boys in June of 2016, and the property sold to Sanctuary Inn beginning of the next year, if I remember right, 2017.
So the first part of 2017, they took over.
Correct.
Okay, so in the first quarter of 2017,
That would be correct.
and is that when your employment there then terminated?
Yes.
Okay, so was there ever between the time when you first started working there until June of 2016 any gap in there at all where there were no boys staying at the facility?
No.
Could you speak up, please?
No gap.
Okay, I have no further questions of Mr. Geisinger.
Thank you.
You're welcome.
Okay, so the one last piece of testimony is I'll just ask the hearings officer to if you take judicial notice of 2 cases in the circuit court, Clackamas County Circuit Court. Those are cases CV 09010475.
Just that I didn't quite keep up.
Sure.
Try it again, please.
CV 09010475. And case CV 100208281. And why I bring those cases up is that those are cases where I represented Sun Village, this particular property, against a contractor that wrecked their swimming pool. So those just, if you look at those cases and the facts stated in those cases, I got a judgment against it, but it was an active swimming pool there. I can testify that I was the attorney that represented YGA in a number of things, and that place was Sun Village was continuously occupied from the very first time I passed the bar in 1992 until Larry until they closed in 2016. I helped them facilitate the sale to Sanctuary in 2017. And in 2017, I also helped Sanctuary Inn with an initial little issue related to trying to get their tax exempt status. And we went around sort of with these very similar kind of issues as this. But I can tell you that from my experience as representative of both of those as their counsel, there was a time of approximately June of 2016 till about February of 2017 where there were no boys and there was no activity in there. And that is it was less than 24 months before Sanctuary Inn took over.
Thank you, sir.
Yeah, and that is basically all that I have.
All right. Did the county have anything further that the county was seeking to add or ask any question here? I didn't think so. Are there members of the public present who would like to provide input, testimony, or a statement? Use the raise hand feature.
I have Van Weigel.
Van Weigel, okay. Would you please state your name and the spelling of your name?
Yes, my name is Van, V-A-N, and the last name is Weigel, W-E-I-G-E-L.
And your address?
That's 25481 East Arawana Boulevard, Welch's, 97067.
Thank you, sir.
Yeah, thank
Go
you
ahead.
for allowing me to say a word or two. First of all, I wanted to emphasize how much we've appreciated Sanctuary Inn as our neighbors. They've been fabulous neighbors, and they have a wonderful mission, as many of you know. But I also wanted to add that the continuing existence of Sun Village through the summer of 2016 was something that was public knowledge around here, because when we closed on our house in October of 2016, our realtor, Dave Lithgow, who has lived here all of his life, mentioned about this change that had taken place. And at that point, things were somewhat up in limbo as to who would take over the property. And of course, then a few months later, Sanctuary Inn occupied the property. So I wanted to add that to the testimony, that this was widely understood by people who had been here in the area. And the only other thing that I want to mention, and this is maybe along the lines of being a bit sentimental, but the property that we're talking about was of course the very cherished property of the elder Fred Meyer. I think he called it Ava's Garden. And it's a beautiful place. It's a place that really allows people to get in touch with themselves and to enjoy nature. And so I really feel like the work of Sanctuary Inn and what is being contemplated in this expansion is something that will not only serve our local community well, but the people who have been in stressful situations around the world, who come back to experience some sense of normalcy and getting in touch with processing their own experiences.
Thank you, and thank you for the little bit of history about the property and for your citizenship participating this morning.
Thank you. Thank you.
Do we have another public participant? No. Okay. As I stated, I would discuss, I have a statement about leaving the record open. Does any party or member of the audience want an opportunity to provide additional evidence, arguments, or testimony? Does the applicant wish to waive the period for final written argument? As I've already discussed with the applicant, the record will stay open for an additional 2 weeks. Do we have any other participant that wants to make a comment about keeping the record open? So the record will stay open for 2 weeks from today to submit additional evidence. So let's just get a calendar on that. I have that is, Halloween, the 31st. Is that what we have? Is that what you see, Darcy? Okay, so 2 weeks. So for the submission of additional information to 4 p.m. October 31st by 4 p.m. Then an additional week for any rebuttal. I don't anticipate receiving any rebuttal. So if there is no rebuttal, the applicant can submit to the county, to Ms. Fields, and she'll forward it to me, a request at that time to waive the period for final record if the applicant so chooses. Otherwise, the record will stay open till November, I believe it's going to be November 7th or November 7th for rebuttal. And then till November 14th to close by 4 p.m. Mr. Linkus, was that clear? I think you
Yes,
may.
it was. Yes, it was clear.
Did you have any other comment about that?
Not at all.
Okay, so if you choose to waive the period for final written argument, submit that written statement, an email is sufficient to Ms. Fields. She'll let me know that the applicant chooses at that time to waive the period for final written argument. You're welcome to submit a written argument during the initial open record period, summarizing the evidence that you submitted in support of this application. All right. With that, I will close the hearing, keeping the record open as we just discussed. Thank you all for
Thank you very much, Mr. Cox.
Thank you.
Thank you.
Thank you, everyone.